All right, we are live. We are live on Facebook. Uh, Good afternoon, everyone who is in the room. I'm Richard V. Together with me is a good friend of mine and the legendary, in my words, legendary Mr. Nick DiMarco, Queen's Counsel from Blackstone Chambers of UK. How are you, Nick?
Very good. Apa kabar. Did I say that okay?
Spot on, mate. Spot on. Apa kabar? Yeah. Kabar baik. And together with us is Miss Wong Ziying. She is the director of the Sports Arbitration Mooting Competition, SAMCO. She's joining us as the co-host for today. Let's set up some rules first. This webinar is an interview with Mr. Nick DiMarco. The perimeter of the interview is about the understanding of sports arbitration. We prepared this webinar in view of the upcoming SAMCO, Sports Arbitration Mooting Competition 2022. And we want to thank Nick, who woke up very early this morning. It's 9 a.m. in England, to spend an hour with us here today. And the way we are going to hold the webinar is like this. After we go through the introduction about Nick and who Nick is, we will then speak a little bit about what is sports arbitration. But Nick will be focusing on sports, the advocacy in the sports arbitration, which will assist the law students who are here to watch the webinar today. After that, Nick and I felt we should have a discussion about Nick's experience. He has gone through some tremendous sports dispute in recent years, and some of it was invaluable for us to hear an inside view of how Nick fought the cases. So that's how it will be today. So, quick introduction. Nick DiMarco is a Queen's Counsel QC from England. He's one of the go-to barristers in sports dispute. He deals with agents, clubs, he deals with sports governance, you name it, he has done it. Recently, he dealt with a huge transaction of an English Premier League club. He will talk about it later. He even is an author of a book called Football and Law, and I believe the second edition is coming up soon. And in the newspapers, he's often referred to as the Lionel Messi of sports law, and I think he rightly earned that title because of his creative ways in coming up with his argument. So, Nick, how are you? All yours, Nick?
I'm very good, and thank you very much, Richard, for inviting me to speak to you and all the students. I said earlier hello in Malaysian, I hope, but I understand you also have people from Brazil, India, Indonesia, as well as Singapore, Malaysia, all tuning in. So it's nice to speak to everyone. And Rick has kindly invited me to speak before in Malaysia about sports law. He is very nice in what he says about me, but very modest about himself, because he has been over the years central to the development of sports law in Malaysia. And he's currently, I understand, the chair of the Professional Standard and Development Committee of the Malaysian Bar, and a member of the Sports Ministry's panel of experts. And he has been involved in organizing a number of events, flying the flag for sports law and things like this arbitration competition, which I think really is helping develop that sector and this area in that regional area. So thank you very much for all the work you do, Rick. And I look forward to being able to join you there in Kuala Lumpur again soon and speak live rather than virtually. I think in terms of what I was going to say and my talk, I wanted to focus on the issue of advocacy, as Rick says. I just want to check, can you still hear me? Because Rick's frozen on my screen. So I want to be sure that you're all hearing me still.
Yeah, you are audible.
Yeah, fantastic, good, okay. So yeah, I really want to talk about advocacy in sports arbitration, because hopefully that's useful to those of you who are students and participating in the SAMCO mooting competition, but also those who are maybe professional advocates already practicing in this area or practicing in other areas and might want to know what's the difference with sports arbitration to other areas of practice where you do advocacy. And before I do so, I wanted to just say something about advocacy and mooting generally, and give you a tiny bit of history. A long time ago, over 20 years ago now, when I first started studying law in the late 1990s in UCL University in London, I had decided that I wanted to qualify as a solicitor. And the reason for that was because, much as when you watch TV and see these barristers in wigs in those days making speeches, it may have appeared an attractive thing to do. I was certain that it was impossible to be a barrister unless you were from a certain privileged background, which I hadn't come from. And I'm just checking again if I can. Is my signal okay? Good. So anyway, I thought not possible to be a barrister. I'm going to be a solicitor. It's all good. I had no ideas about sports law back in those days. I don't know if it even existed as a curricular item. But the one thing that I did is I started getting involved in mooting competitions in my university. And then I started representing my university and going around the country in mooting competitions. And I was lucky enough to win some national mooting competitions and university mooting competitions. And I decided I really liked mooting. I really enjoyed it. And I figured out that I was perhaps good at it, maybe better at it than my exam skills or written. It was the one thing I felt really confident about. And that was why, in the end, I decided to become an advocate and a barrister because of that. But going back to engaging with it, I think the lessons I learned from that are just as valuable today in my advocacy and just as useful for sports advocacy or sports arbitration as anything else. It sounds simple, but the main lesson I learned from preparing for those moots back then and why I thought I was able to win them was that it was all about preparation. And again, that does sound like really simple, but what I mean by that is it was all about looking at you often had in those days, I don't know how you do it, you often had a 1 paragraph question, problem, or a 2-page case or whatever it is. There's not much there. And what you have to do is not just think about your argument, how you're going to win this case with your argument, your best 3 points, try and condense them down. You don't just think about that. What you need to think about is every possible argument against you. You've got to put yourself in the shoes of your opponent and think, how do I rip down the argument that I'm going to make? And then you have to think of every objection the judge is going to make, every question the judge is going to ask. And when you do that, when you thoroughly think, when you take apart a problem and look at it from every different angle and try and prepare for every eventuality, almost like playing a game of chess where you try and think 4, 5, 6 moves ahead, not just the next move. When you engage in that level of preparation, you can then start preparing for the moot, because you can then say, all right, now I've done all of that. So now I go back to working out my best 3 points. I put it into a, however long you have, 10 minutes, 15 minutes, whatever your rules are. I put it into a nice section and I have those 3 points. But because you've done that previous preparation I've told you to do, because you've done that first, what then happens is something unexpected. The judge or arbitrator will ask you a question that maybe is not in the script, or the other side will come up with an argument that is not in the script, but you have already prepared for it. So you have off the top of your head the answer to it. And that is where you'll shine, because anybody can read out a speech, but when you deal with the unexpected, that is where you're really tested. So that's my one big hint at the very, or one big recommendation at the very outset of this, and it applies just as much in any advocacy, in sports advocacy, as anywhere else.
Nick, sorry, I don't mean to cut you off, Nick.
No,
but
please.
fantastic start, because the whole idea of doing this webinar is to share knowledge with most of the mooters here, and most of them are young law students. So welcome aboard. But also good news is that we have some non-mooters here who are sports administrators and whatnot, and they would like to also probably understand a bit about sports arbitration.
Yes.
So from your experience, you do sports arbitration on a weekly basis.
Yes.
What would you say would be the main feature of the sports arbitration, and what would be the main difference between the sports arbitration and, say, the commercial arbitration?
Yes, it's a very good question, because in some ways arbitration is quite different to court, because when we normally think about it, court is in public, arbitration is in private. Court decisions are binding on everybody. They are public decisions. You have systems of precedent, especially in our common law system. Whereas arbitrations are only binding on the parties that take part in that arbitration. The decisions are not published. So normally there is a pretty big difference between court proceedings, public court proceedings, and arbitration, commercial arbitration. Sports arbitration is different, because sports arbitration is somewhat of a hybrid, in my view, between public decisions and public court decisions and commercial arbitration. And I need to be a bit careful about saying it's a hybrid, because sports arbitration itself includes a wide variety of things. So within sports arbitration, you do have what I would describe as purely commercial arbitration, disputes between an agent and a club, or two clubs, which is just about money, and it's only binding on those two clubs. But you also have, and this is probably what you are most familiar with as someone looking at it from either the inside or the outside, you also have what I call regulatory decisions. So if you think of all the doping decisions, if you think of decisions involving FIFA or any of the world governing bodies over things like the status of players, all of those sorts of things, those are regulatory decisions. And the importance about that is that those decisions have to often be in public, or at least the judgments have to be in public, and that they will bind other people, or they will set some form of precedent, even though they might not call it a precedent. And so you will rely on a CAS case in a particular doping dispute where they've decided something on a similar fact. You would never normally do that in a normal private commercial arbitration. And I think that's a very important difference people have to realize. It's in that sense more like public court proceedings.
But fantastic. I like the part, Nick, where you clearly differentiate that there are some sports arbitration decision which is so important that it regulates the entire industry. And if you can expand a little bit further on that, Nick, like especially decisions on doping, where how CAS decide. CAS, of course, ladies and gentlemen, is Court of Arbitration for Sports, based in Switzerland. So CAS, when they hold a decision that certain drugs is yes, certain drugs is no, it will actually affect the entire sports industry, isn't it, Nick?
Yes, and the doping is perhaps the best example, because you have an international code, the WADA code, which sets out the prohibited substances, the doping, the things that are doping. Everybody has to follow that in every country, regardless of the law, regardless of the courts, in the sports of every country. It's an international code. But not only that, it has a system of mandatory sanctions. So you get banned for 8 years for intentional use, 4 years for non-intentional, depending on the drug, 2 years if you can prove no significant fault. And then what you have is a whole system of jurisprudence, and the top court in the world in terms of that jurisprudence is the CAS in Switzerland, as Rick has said, Court of Arbitration for Sport. And that jurisprudence looks at difficult questions like, for example, proportionality, because to many of us lawyers, to impose a 4-year mandatory sanction, regardless of some specific circumstances, might not be proportionate.
Yeah.
But CAS has established in a number of cases that it is proportionate for various reasons, because they say the whole WADA system is proportionate. And so those CAS cases are very important for determining whether in your particular case, the sanction is proportionate or not. You have to look at the reasoning there and apply it or distinguish it, and so on.
And I was just wondering, Nick, from back to the advocacy point, now that we have established how sports arbitration is, and sometimes it's commercial in nature, but it can be regulatory in nature, important cases like doping. So when you as a barrister preparing your advocacy in preparing for this hearing, what would be your process in preparing, and maybe you can share some insight in your thoughts on how you approach the case, each and every case?
Yes, well, the first thing, again, it may be obvious, but it's to know your tribunal and to know the rules of the tribunal, because they are all very different. And in some ways, I find appearing before the CAS quite difficult, because it is very different to appearing before not only an English court, but an English arbitral tribunal. As Rick said, I appear before many different sports arbitration tribunals in England: the Premier League Tribunal, FA Rule K tribunals, the Football League Tribunal. So even in football, there's 3 different types of arbitral tribunal in England. And we have many cases before all of them. And then I might appear before a rugby case, a rugby tribunal, you know, many different types of tribunals, boxing, that we have many different ones with different rules. But broadly speaking, if they're in England, under English law, the approach to the advocacy is quite similar to how it would be in an English court. In CAS, it's very different, because most of the lawyers in CAS who sit as arbitrators are civil lawyers and not common lawyers. And so they don't have the same approach in terms of things like precedent in cases, but also things like cross-examination. It's less argumentative, it's less adversarial than the common law system. And so you have to be careful not to be as adversarial, perhaps, as you would be before a CAS tribunal, depending on who's on it, as you might be before an arbitral tribunal in Malaysia or Singapore or England or India, or where you have a more common law and adversarial system. And so knowing that, and sometimes, to be honest with you, you don't know until you're actually there, because just because an arbitrator is from Switzerland and not the United States doesn't not necessarily mean, you mustn't stereotype, doesn't necessarily mean they're not going to like you cross-examining a witness, but you'll pick up very quickly if they don't like it. And you'll pick up very quickly if you're attuned, and this is why I say knowing the tribunal is very important. Do the research on them first, learn their rules, find out the background of each arbitrator. But then when you're there, that's the main thing. Look at their body language. Are they following you? Are they interested? Watch their eye movements. See if they don't like what you're doing. And if they don't like what you're doing, you might have to carry on doing it, but try and do it in a way they may find more palatable. Try and adapt and change while you're doing it. You've got to keep putting over your client's case, your argument, but you've got to do it in a way that does not alienate your tribunal. You've got to do it in a way that persuades them. So knowing your tribunal is key to all of this.
Good point. You know, many people don't realize, Nick, that when you do sports, but you and I, we have appeared in the normal commercial cases where we may argue on the company's law, or I know you do media law, for example. You probably argue on copyright law, intellectual property law. So it's just that law. But when you go to do sports, it may be sports, but it depends on which sports you're arguing. So today may be cycling, tomorrow may be wrestling, and then different sports. And some of us here, I have a leader from a lion dance troupe, one of the top Malaysian lion dance troupe is here. Mr. Albert is here, and I also have a friend, Kenny. Kenny is he's from the mini football of Malaysia, Kenny Low. So these are sports administrators. They have their own rules, and when we argue their case, we would have to argue their rules, Nick, right? So I think you have to switch all the time, isn't it?
You have to, and I say this: the most important thing is the law, knowing the law first of all, and that means in sport not just knowing one set of rules or laws. It means, as Rick said, a good understanding of commercial law, employment law, and then some other aspects like media, copyright, sometimes competition law, and so on, some international law. There's so many different public law, regulatory law. There's so many different areas of law that arise in sport. Nearly every area of law arises in sport. So you first need to know the law well and study the law well, but then you also have to apply it to the facts, and the facts will be very different depending on the competition. So a few weeks ago, I did a big case in a rugby union arbitration, and the issue involved a lot of quite important disputes around what's called a tight head prop and a loose head prop, which are different types of props in the scrum of a rugby union team. Now, before doing that case, despite being a sports lawyer of many years who've done many rugby cases, I had no idea what a tight head prop was or a loose head prop, or what the difference is. Yeah. So obviously I see it in the papers, I have to look it up, I have to learn it, maybe watch a video on YouTube, try and understand it. You have to do all of those things. You were talking about CAS. One of my first big CAS cases was a dispute in the America's Cup sailing about cheating in sailing. And it was all about how, it sounds a little counterintuitive, about how the winner of a particular America's Cup competition had cheated by putting more weight on the boat than you're allowed to. And it was about the distribution, where the weight is in the boat, because this affects how fast the boats can go. And again, to be completely honest with you, I had no knowledge at all about racing in sailing or how sailing boats are built, or how they, the terminology used in everything you describe on a sailing racing boat uses highly specific sailing terminology. Which I was just simply not familiar with. But I had to learn it because I had to cross-examine these witnesses about all of these things. And of course, they would answer using this terminology, using this highly specialist language. And if I didn't know what they meant, it would be impossible to cross-examine them.
Yeah,
so
exactly.
You had to learn the mechanics and basics of that sport. I've never done another case in sailing since, and maybe I never will, and I've probably forgotten it all now. But for that case, I was on top of it, and you have to be.
Yeah, spot on. In fact, I do share your experience, Nick. On our side, we do occasionally get sports which we are not familiar with, and we have to really pick up the sport itself very quickly. But I think so long as, and I think you would agree with me, so long as we as sports lawyers understand the governance issue, the internal purpose of the rules, how doping works, the off-field and on-field rules, and how the tribunal works. I think many people don't realize that sports have its own law, own world, and you use the word own jurisprudence. But once you understand all this, different sports, it's just a matter of understanding it, and then we can do it. Isn't it?
Absolutely right. Absolutely right. And that's why I said, you start with the law and start with the understanding of the rules and the approach generally. That's most important. In a way, it's no different to when I was not specializing in sport and more of a general commercial lawyer, and I would have an injunction dispute, and the background would be about a factory that made ball bearings or whatever, and it was about someone had stolen the secret of how they made that ball bearing. So for that case, you have to learn all about the mechanics of making that ball bearing.
Yeah,
And then
yeah.
for another case, something completely different, and you forget all that, and you're looking at exhaust fumes from a car or whatever it is. You know, commercial lawyers have to do that all the time. In a sense, it's the same with us as sports lawyers. We understand the law and the approach, and then we've got to learn the specific facts of a particular sport or a dispute in a particular sport. But it's not the knowledge of the sport that is most important. It's the knowledge of the law and then applying that to the sport that's most important. So, you know, sometimes people come along and say, I really want to be a sports lawyer because I love sport. Well, that's great. It's good to do something you're passionate about, but you can be a good sports lawyer without loving sports or without loving all sport. I don't love all sports. Some of the sports that I do cases in, I probably wouldn't watch for 5 minutes on television unless I had to help me for that case.
Yeah.
Other sports like football, where I do most of my work, and I do enjoy and I do watch, but you don't have to love sport to practice in sport.
Nicely said. Well said. So there you go. It's only 4:30. Ladies and gentlemen, so far you have heard at the beginning of the talk, Nick delved straight into the issue of advocacy, of arbitration. He gave some nice pointer. I'm going to come back to that soon to get some tips from him to help the students here prepare. Then, as you can hear, he very, very succinctly and made it very clear how sports arbitration is often different from commercial arbitration because of the regulatory and the commercial and public impact of sports arbitration. Then he gave some very interesting insights of his personal experiences. And then you just heard him talking about how different different sports will have to be treated differently, but so long as we have the basic principles. Now, if you have any questions, ladies and gentlemen, feel free to put it in the chat box below. We'll start addressing the questions at Malaysian time, 4:45 p.m. I do want to let Nick go soon because it's his weekend and you know he works long hours. So I think Saturday is the only time we can go and have a nice breakfast. And I'm only stealing 1 hour of his time. Now, on Facebook, Nick, there's some people already log on and I saw some questions there. I'll bring them over here later. But for now, let's continue. So Nick, maybe many people may not know, but you are actually very well known in football. In fact, football clubs across England, definitely, and Europe generally, when you mention Nick DiMarco, they will say, oh yeah, that's a barrister. We go to him. So maybe you can share with us some of your, subject to privacy, of course, and subject to privileged information, maybe some interesting cases, because in Malaysia, we are football men. And everyone knows that you are Newcastle lawyers. That's what goes to show how detailed they know until who the lawyer is who argued the case. So I leave it to you, Nick. Maybe you can share some.
Okay. So you mentioned the Newcastle case, which was probably one of the biggest cases I worked on in last year and the year before, because it took about 2 years of work on that case. And that, by the way, is unusual for a sports case. Most of my sports cases are quite small in terms of the amount of work. There are, you know, I've got a few cases on at the moment which will lead to a 1-day hearing or a 2-day hearing, and you may be working on them for a few weeks on and off before the hearing, or a few months. So it's unusual in a sports case to be working on the same case for 2 years, nearly every day, 12 hours a day, and the weekends, because that's what that Newcastle case took. But it was obviously a very important case because it was all about the Saudi investment fund, the investment fund of Saudi Arabia, the PIF, being able to buy a controlling stake in a Premier League club. And there was all sorts of political and other fallout about that for various reasons. But actually, probably the most important one, and I'm not sure the extent to which this was understood internationally, and I say this because the arbitration was confidential, and I'm not allowed to talk about anything in the arbitration, but what I can talk about is what has been reported in the press. So what I'm saying was reported in the press, at least the English press, is that one of the main issues was, at the time, the Premier League's biggest commercial supporter outside of Sky, where they get they sell their broadcasting rights. So they're second biggest, but they're biggest in the EMEA region, in the whole of Asia, the region most of you I'm speaking to are in. Their biggest commercial partner was a company called beIN Sports, which is based in Qatar.
Yes.
And they had the exclusive rights for the Premier League. And of course, there was the political issue between Qatar and Saudi Arabia. And there was an allegation made by beIN Sport that Saudi Arabia was allowing piracy and taking the beIN product, i.e. the Premier League, and playing it for free. And this led to a huge commercial dispute worth hundreds of millions between essentially Qatar and Saudi Arabia. And so the suggestion was that beIN Sport, as a multi-million, if not billion-pound sponsor of the Premier League, was putting pressure on the Premier League to stop the Saudi Public Investment Fund purchasing a controlling share in Newcastle. So essentially, you had a global political issue and a huge financial commercial dispute played out in what was a football arbitration in England, which eventually was resolved and settled without coming to a final hearing, and allowed the takeover to go through. So we got what we wanted, because I was acting for Newcastle and for Mike Ashley, the then owner of Newcastle, who obviously wanted to sell, and did sell. So that's an example of one case. But to give an example of so in a way you could say, well, what's that got to do with football? It sounds as if it's got to do with just about everything else except football. But of course, it had a lot to do with football, and there's still lots of argument about it and similar cases, because it meant that what is one of the biggest football clubs in the world in terms of its support and history, Newcastle United, now has probably more investment or ability to have investment than any other football club in the world, because of the resources of the Saudi Investment Fund, such that it can now potentially compete with the top 6 clubs in England: Man United, Liverpool, Arsenal, Tottenham, Chelsea, Manchester City. It could perhaps break that hegemony of the top European clubs in Europe. So it could be a fundamental change in football as a result of that case. And that's why it was so important and popular with the Newcastle fans. Another example is Derby County, who I was acting for again about three to 4 years on various different cases. But the most important and significant was to do with financial fair play. And again, this demonstrates how wide football issues are. Financial fair play is all about rules that limit the amount that football clubs are allowed to spend, or rather allowed to have in debt, because there is an economic pressure due to high player wages and clubs competing for the top competitions. You have, generally speaking, certainly across Europe and in England, clubs overspend. Very few football clubs make a profit. They spend more on wages than their revenue. And so financial fair play rules are about limiting the debt that they are allowed to have as a result of spending on players. And although it's presented as something that, if you like, creates a level playing field between clubs, so that you don't have one club spending more than another, it has nothing to do with that at all, because you do have clubs spending much more than each other, because it's about their debt. So if you're a Manchester United, which is one of the clubs with the greatest income in the world, it's able to spend a lot more money than a Burnley in the same division, because Burnley has a much smaller income. So in fact, it stratifies, it maintains the status quo between the big clubs and the small clubs, these financial fair play rules. And so when you had a club like Derby with a successful owner at the time wanting to invest more money so it could compete and get in the Premier League, he tried to do so in ways that didn't break the financial fair play rules, but the Football League decided that it did, and we had 2 years of cases on whether or not the spending breached the financial fair play rules. And this went down to things like the club sold its stadium to its owner so that it could have in its books the profit from the stadium sale. And so there was an argument that we had lots of expert evidence and months of preparing argument about how do you value a football stadium, with expert evidence on both sides. So I give that as an example of a very big arbitration I was involved in, which again, to many people watching, might not obviously be about sport, but it's actually about the things that allow football to be as successful as it is. It's about the money in sport.
It's basically a governance issue.
It's a governance issue, but it's really all about financial regulation, which is now one of the biggest issues in football, but also in a number of other sports like Formula One.
Oh yes, they control the one. But in that Derby's case, unfortunately, I think they were deducted 21 points, right?
Yes. So they were deducted points for the breach of the FFP rules, the financial fair play rules, and for then becoming insolvent. But the points deductions were accepted by Derby. So this was after our cases. So during our cases, we managed to stop any points deductions being imposed. But then after Derby became insolvent, a settlement happened, and they voluntarily accepted a points deduction. And they are now in the process of trying to find a new buyer.
Yeah, they're quite sad, I must say. But Derby is quite a prominent club. People don't realize that in the 60s and 70s, they were a very big team.
Yes, but champions of Europe.
Correct. They're former champions, correct.
And Brian Clough was their manager when he was one of the best managers in Europe. Yeah,
correct.
One of the founding members of the Premier League.
Yeah.
Absolutely. Yeah.
I think many football fans in Malaysia, they believe football started in 1992. They don't realize before 1992, Aston Villa were champions, Wolverhampton were champions, Leeds were champions. I'm talking about European champions, not just champions.
Yes. Nottingham Forest.
Yes, Nottingham Forest, yeah. So, and even your club, Queen's Park Rangers, they were in the top division for many years.
Yes.
Now, of course, they're still in championship. But I think it's a matter of time once they get things right. They seem to be playing better this season, isn't it?
They were for the first half of the season. Then it went down.
They fizzle out, yeah.
But of course, we have some of our owners are Malaysian, so I hope that we have many fans in Malaysia for Rangers. Tony Fernandez is still involved in the club, along with some of his partners.
Yeah. In fact, most Malaysians know QPR because of Tony. Yeah, but I'm the old guy, so we know QPR those days.
Yes.
Even before Les Ferdinand days, we were following QPR. Okay, anyway, back to this. So we've got some questions here. It's 4:40. I think as we answer the questions, I think Nick, you can also address some of the issues that we have planned to speak about. Like, for example, your tips on how to address the issue, blah blah blah. Now, but there's one question here from Simran, which I would like to answer first as an organizer of SAMCO. Simran Baradia asks how to handle a moot proposition when you don't know which sport is it. Now, Simran, for moot competition, particularly for SAMCO, we have purposely choose to create hypothetical sports because the sports doesn't matter. It is the moot which matters. And we want you to understand, like last year's moot was about doping. This year's moot question is about an athlete which was suspended or disqualified after arriving late at the arena. So it doesn't matter what sports the athlete play, but because the athlete came late and then took part and went on to win the goal, but later on the organizer held, no, you're out. So does this go to the root of the competition? There are CAS cases decided on this, Simran. So that's why, and to avoid any conflict, we don't want to suddenly use football as an example, and then we receive a letter from FIFA saying that you never asked my permission. So we don't want to go through that hassle. We just created a hypothetical question. So Simran, I hope I answered that question for you. The next question, this is meant for Nick. Good question from Hajar. The question is, does sports law fall within public law or private law? Nick?
Well, that is a very good question, and there's a debate about that, and it may be different depending on which country you're in. In England, it's generally been established that sports law falls within private law, and the reason for that is because the sports governing bodies, for example, the Football Association or the Premier League or the Rugby Football Union or the English Cricket Board, any of the sports governing bodies are all private bodies. And therefore they're not, as we call it in England, amenable to judicial review. They are not government state bodies. So therefore it's private law. But, and here's the big but, because they have a monopoly control over the sport and the way they behave and function is somewhat similar to the way public bodies with similar control over areas of life have. And in particular, because they control someone's ability to earn a living, if a sports governing body bans an athlete, that athlete may not earn a living as an athlete. And you can only play that sport if you sign up to the rules of that governing body. Because of that monopoly control, the courts have decided that the standard of that they will have a review, a supervisory review over the decisions of the public bodies, the private bodies, the private sports bodies, and the standard of review they will have will be the same as in public law. So it's private law, but where the courts can intervene, they'll intervene with a public law standard. Therefore, the answer is really a bit of both. And that's why you have to know both private law and public law to be a sports lawyer, certainly in England. This gets further confused by the question of arbitration. And as we're dealing with arbitration, I address that because in most cases, the sports do not have supervisory jurisdiction over the decisions of, for example, the English FA. Not only because the English FA is a private body, but more importantly, because all the sports governing bodies in England, nearly all of them, have mandatory arbitration clauses. So they say, if you are a player or you are a club and you don't like our decision, you can't go to the court. It's not allowed. You have to go to an arbitration. That's why Newcastle had to go to the Premier League arbitration to challenge the decision of the Premier League. It could not go to the court, even if it wanted to. But then still, that arbitral tribunal, that private arbitral tribunal, will apply the public law standard of supervisory jurisdiction in determining whether the decision of the body was lawful or otherwise. So again, you have private and public law mixing in sports law.
Interesting. In fact, correct me if I'm wrong, Nick, there is a British English, I think, High Court decision which held that a particular sports body can be judicially reviewed. I think you're referring to that case, right? I was trying to find the name of the case, actually.
Well, the most important case about what I've just described is called Bradley and the Jockey Club.
Yes.
And that's a case from, I think it's the late 90s. But if any of you ever, just Google it, you'll be able to find it online in various places. And that's a High Court decision of Mr. Justice Richards. And it was then went to the Court of Appeal, and the Court of Appeal approved it, but it's a High Court decision that you need to read. And that's the case which says that although you can't judicially review the decision of the Jockey Club, as it was then, the court has this supervisory review, and the review is the same as it would have in public law. The same as if it could judicially review.
Correct.
And so that's the leading case, Bradley and the Jockey Club, and it's ever since that has been the case in England. And broadly speaking, you see the same approach through a different route in other countries. So, for example, CAS is the Court of Arbitration in Sport it's a private body, the CAS itself, but because it's based in Switzerland, it is ultimately subject to Swiss law. And that means it's ultimately subject to the supervisory jurisdiction of the Swiss Federal Tribunal, like the English High Court, which will apply similar standards.
Interesting. In fact, I can share with you, Nick, that question of whether or not a sports body can be judicially reviewed have not been tested in Malaysia. And but my firm, we've been keeping an eye on this area because I think it's a matter of time. Someone will be testing it. Someone will be challenging it soon. So we'll see how it goes from there in Malaysia. I'll let you know the development from
Yes.
there.
Yeah, and certainly in some countries it has been the case that the sports governing bodies have been subject to normal judicial review, normal public law, and in other countries they haven't. So just because it's done that way in England doesn't mean it will be the same in Malaysia necessarily. And in addition, one final point on this is that at the moment there is a proposal for a new independent regulator for football.
For football, yes.
For football. And it's come out of a review led by Tracy Crouch MP, who I'm actually chairing a panel with her on in a week or so's time in Law and Sport. Should be a very interesting panel. The English government, in the Queen's speech a few days ago, the British government has said it will introduce legislation to bring in an independent regulator for football. It's an interesting and controversial area, but one interesting question that arises from this that I don't think anyone else has yet picked up on is that if this independent body is a statutory body backed by statute, which is the current proposal, then it may well be subject to judicial review.
Exactly, yeah.
And so then there's 30, 40 years of English or 30 years of English jurisprudence that the Football Association or whoever is not subject to judicial review may suddenly change.
Yeah, I agree. It's possible. Well, I think that was in reaction to the few football clubs who wanted to join the Super League last year, remember, right? And
that's part of the reason, yes.
Part of the reason, yeah, I read about it. Yeah, we've been following that in Malaysia, and we'll be waiting for the decision, and then probably we can learn from that in Malaysia too. Now, good points, Nick. Good points. Now, the next one is Simran. Again, thank you, Simran, for your questions, and I hope we answered Hajar's question. So I'll take both the questions at one go. Basically, Simran inquired about some procedural matter. Of course, Simran, to be fair to Nick, he's a barrister, and usually these matters of the time gap to file an appointment, etc., that will be handled by the solicitor, and particularly in England. I think Mr. Nick DeMarco will engage, or let the solicitor will do it, and then they will engage Mr. Nick to come and argue out the case. But I think the second part, where the question from Simran, Nick, is that if there is a sanction of 6 months suspension on the athlete, and the person is appealing to CAS, will he still have to comply? In short, I think there are questions: is there a stay? What is your experience in this kind of situation, Nick?
Again, it all depends. It all depends on the rules of the body, and there's usually a discretion. So in CAS, generally, there is a discretion. They can take what's called provisional measures, which includes suspending sanctions. Generally, the approach is where an athlete has been banned for a lengthy period, and it's not possible to have the hearing very, very quickly. The general approach will be that you can have that ban stayed, you can have it put aside pending the decision, but it depends, and it depends how serious the offence is. It depends on the quality of evidence. It depends on the rules of each sporting body, and there are lots of cases where suspensions have not been set aside because of an appeal. So it will depend on each case. I'm often involved in these types of cases, and I can tell you sometimes you don't want the suspension set aside because you might be in a period of time where the athlete's less likely to be competing, and you're thinking, well, if the time can take place now for a couple of months, by the time we get to a hearing, if we win, then fine. If we lose, we've already served 2 months, and so the next 2 months isn't so bad. So you don't even always apply for it to be stayed. All these things are very factually dependent, specific dependent on the circumstances of the sport, of the offence, and of what's best for the athlete. But generally speaking, there will be at least a discretion to count the period of suspension or to set aside the period of suspension, depending on the rules. Although you're right, Rick, it's usually solicitors who do the administrative side of appointment of arbitrator. I will often get involved in recommending arbitrators to my solicitors, because I'll usually have more knowledge of them and appearing before them. And so in terms of your earlier question, Simran, about the time gap between the appointment of the arbitrator and the hearing, does that affect the procedure or its efficiency? Again, I'm going to give this, you're going to think I'm a broken record. It really depends on the circumstances. I mean, often there's not a huge time gap. I have been doing arbitrations recently in England where, because of the nature of the sport, we've had to appoint an arbitrator on Monday and have a hearing on Wednesday or Friday.
Wow.
And actually that can be far more difficult for everybody than having a time gap. On the other hand, you can have CAS cases where you wait 2 years to have a hearing sometimes, at worst. And that can be very inefficient. So the time gap itself varies a lot depending on the sport and how urgent it is. But it's not the time gap between the appointment of the arbitrator and the hearing itself that's the problem. It's a time gap between bringing the claim and the hearing, which may be the same thing, but you've got to appoint the arbitrator as early as possible, because the only way you're going to have a chance of getting the hearing on earlier or getting proper directions for the hearing is when you have an arbitrator appointed. So the worst situation is where you bring a claim and you have an argument about who is the arbitrator, and you then have disputes about the arbitrator, and that can in some cases take months and months and months, and then you can never even have an arbitrator to set the directions for a hearing. And that's the worst position.
That's the worst part. I know exactly what you mean, because we have that problem for the commercial arbitration here. Sometimes we can't agree on who's the arbitrator. But good questions from the delegates here. Thank you for your questions. Now, to kind of wrap things up, maybe we're coming to 4:55 in Malaysia, five more minutes. Maybe Nick, I would like to invite you to give your words of wisdom. You've been doing this for a long time, and you didn't become a QC just like that. You need to build, you need to build this reputation, standard, status, etc., etc. Maybe could you share your personal aspirations, personal advice to all these budding young lawyers and to those sports administrators? How would you tell the person, like, this is what you can do to become a sports lawyer, to become an arbitrator, or to become a barrister? All yours, Nick.
Okay. Well, firstly, on the advocacy side, I'm going to repeat what I said before because it's key. It's all about that thorough preparation. It's all about that. And I'll give an example of the CAS case I mentioned to you before about the cheating in sailing. It's a good example of this, because in that case, and in a lot of CAS cases, you don't get witness statements. I don't know how it is in Malaysian courts or commercial arbitration in Malaysia, but in England, in private law generally, and in public law cases, except for criminal, in England, we have witness statements before the hearing. So I can read the witness statement and I can prepare my cross-examination. Generally, in CAS cases, you don't have witness statements. I had to cross-examine 5 witnesses without knowing what they were going to say before they spoke. I found that very difficult because my way of preparing is normally I have the witness statement and I can see where that's inconsistent with the documents, or inconsistent with what the other witness says, or even inconsistent with what the witness is himself saying or herself in the same statement. And I prepare my cross-examination based on that. When I have no witness statement and I have no idea what this witness is going to say when he turns up and gives evidence, it's much harder to prepare. But all that means is you must prepare more. You must know the case backwards, so that you're able to react to evidence that you were not expecting when you first hear it. And so, again, counterintuitively, and it's maybe a guide particularly for mooting, the thinner the papers or the shorter the problem, sometimes the more difficult it is. If you've got a folder with all the witness statements and all the evidence there, it may be easier to prepare than those tiny little bits of paper you get sometimes from a sports body that don't tell you much, and you then kind of have to prepare more because you've got so little to work on. So just because something looks small, don't think there's not a lot of work. Try again and think of every eventuality. So preparation, but in a different way, in answer to the other part of your question, Rick, which is about how does one become a sports lawyer, not just how does one become a good advocate. And just staying on that good advocate for one last thing, the advocacy itself, how you deliver your speech, making sure you don't speak too fast, making sure you speak clearly, making sure the arbitrator is listening to you and following you. All those are things you can learn, and anybody can learn, in my view. They are not God-given skills at all. Any of us can learn those. It's the preparation and the work that's key. And I'll say the same about being a successful sports lawyer. There are things you have to do, like joining this competition, going to events about sports law, reading about sports law, writing articles about sports law, networking, sometimes doing, when I started, a lot of pro bono work for sports bodies to get some experience, to get to know people, to get some of that work. There are all those things you have to do to take opportunities to be a sports lawyer. But again, all of those things are things any of you can do, and anybody can do if you want to do them. But the key thing is to be a good lawyer. Again, it's a kind of obvious point, but the key thing is to understand commercial law, employment law, regulatory law, the key elements, understand them well, learn how to apply them to sport. And then when you get that one opportunity, you'll do well, and the client will remember you and say nice things about you, and you will hopefully get another opportunity.
Yeah. Well said, thank Nick. Well, anyway, can I invite everybody to give Nick a big cyber round of applause? You know, he could have been anywhere else on Saturday morning, but he chose to be with us here today. Thank you, Nick. I thought what you commented made a lot of sense. I think a lot of what you said would sound true for them for when they prepare the moot competition, and for those who are not mooters, they'll probably now start pondering that, oh, other than being a sports administrator, there's also the sports arbitration. Any final word from you, Nick, before we by the way, Nick, when we finish, don't leave the room yet, yeah, so we can have our own discussion. Any final say before I stop the live broadcast? And
only to thank you all for listening, and please feel free to follow me on Twitter or LinkedIn. You can find me, and when I can, sometimes I'm too busy, but when I can, if you have any questions, I will try and answer them, and good luck, and hope to see you all in Malaysia sometime.
Yes, Nick, that's what I want to talk to you about. So, but yeah, ladies and gentlemen, in fact, Nick hit a spot that I was about to share with all of you. I would strongly implore you to follow his LinkedIn page. Well, he's quite active in the Twitter too, and also I think on Facebook sometimes. And you will soon find out that Nick is an ardent photographer. He takes beautiful shots with his cameras. But you should follow his LinkedIn, because you don't realize, Nick, sometimes when you put up things on your LinkedIn page, I click and read. They're like, oh, this is happening in England. So I really appreciate that update, Nick. Really appreciate that. Yeah. So all of you should do that. And I would like to wish all of you, especially the mooters, the best of luck at the end of the month. You're going to start your moot competition. And then thanks Kenny. Kenny, of course, is from Mini Football Malaysia. Mini Football is a new sports. Nick, it's based in Switzerland, and they form association in Malaysia. It's something like futsal, but it's played on a normal grass, and the pitch is more or less the size of a futsal pitch, but can be played any time of the year. Interesting sports, very interesting sports. Yeah. So anyway, to all the mooters, good luck. To all the delegates, thank you so much. I will bring this live stream to the end, and those who are on Facebook, thank you for following us. You have a good weekend, and as this is a long weekend coming up, have a good holiday for all of you. It's a long weekend here in Malaysia, Nick.
Lucky you.
Yeah. Okay. Thank you for the live broadcast. I'm going to stop the live broadcast now. Thank